you guys getting the stuff on Blackboard, yeah?
Yes, we do.
I put up articles and things like that, yeah. Okay, so we are now being recorded. Great. Right, okay, so today we're talking about revocation. And so what we're talking about here is a patent has been granted. So like as per last week, we've gone through the whole stage of putting the application text together and putting the deed of assignment and making sure that the right person is named and that you filled out all the forms, etc., etc. And now it's out there. And so obviously the opportunity exists for third parties, for in fact any party, to attempt to revoke that patent, roll it back, have it cancelled, because for whatever reason they don't think it's valid. So what's important to understand is that unlike most patent offices, South Africa does not have an opposition proceeding. Okay, so when we talk about patent opposition, for example, the most famous or the most well-known opposition procedure is that of the European Patent Office, whereby the Patent Office grants a European patent, publishes its grant in the journal, in the patent journal, and then that opens a 9-month window for anybody, third party, to jump in and oppose the grant of that patent. And the good thing about that is that it's not heard in front of a judge. It goes back to the Patent Office. So it goes back to the patent examiners but it becomes adversarial because that third party is now standing up saying, you didn't consider this piece of prior art or whatever. So trying to argue it like that. And it's actually quite, it's a very, it's a process which is well used. It's a very good process. So it's surprising that South Africa doesn't have it, but I have mentioned the white paper on the South African IP policy and the changes that they're thinking of introducing, and opposition is in fact one of them. So I think it's likely that we will have opposition in the fullness of time. I've got 10 years left in my career before I'm forced to retire, because that's the thing. When you're in a law firm, they can't have you hanging around forever. So 65.
But at least with this, it will be advantage because as a specialist, even if you are in retirement, they can always consult.
Yeah, they can call me back. But I mean, I think you guys will be in charge then. You will be the young guns in the firm. You won't need me. I'll be an old buddy. So we get the. It's important for us to train people who will replace us, and so that we are not needed. So we train ourselves into irrelevance, really. So that if something difficult happens, maybe they'll call me. But I'm going to be on the beach somewhere. I'm not interested in your story.
Before we proceed, you say that South Africa doesn't have a pendant opposition, which means that when I register something to be patentable, nobody can come and oppose it.
Yep.
Within that 9 months.
Yep. Nothing. No. So the only way you can get rid of a granted South African patent is by way of revocation, and revocation is a high court procedure. Okay. So it starts off by making application. You guys know the difference between application and motion and all the rest of it, right? In civil procedure, it's an application. It's covered in the last paragraph there. Procedure. I'm not going to go into procedure because we've all done civil procedure and we all lost the will to live while we were studying that. So, it's like replying evidence and founding affidavits and 2 months to file your notice of intention to defend. It's not it's an opposed application in the court of the Commissioner of Patents. Okay, so, and if I haven't mentioned this before, I'll mention it again, and I will mention it again. The court of the Commissioner of Patents is considered the Supreme Court. Okay, it's a little part of the Supreme Court. The commissioner is in fact a High Court judge, a Supreme Court judge who's like I said, dude, you're sitting in the court of the Commissioner of Patents today, off you go. It used to be that we had specialist judges who had technical backgrounds who used to sit as the Commissioner of Patents, but unfortunately that practice has gone by the wayside, which means that some of the judgments are questionable because the guys are hearing about the Patents Act for the first time on the day, and they have to have counsel tell them, and each counsel will give them their interpretation of the act or whatever. So if you don't have a judge who's grounded in patents, it's difficult for them to give a good judgment, and some are better than others. But the fact of the matter is, revocation, High Court action, Court of the Commission of Patents is the first one that starts. Where it starts. There is a very interesting case called Deaton Engineering and another versus McKelvey. It's 1997, BIP 53. BIP, I think, stands for Burrell's Intellectual Patent Reports or whatever. No, it's not there. But you can have a look at it. And it talks about what is a court in terms of patent law. And the judge has no, he's quite clear about what's what in terms of what constitutes a court. But if there was ever a question about whether the Court of the Commission of Patents is a court, that case puts it to bed for the long and the short of it. So it's really, it's not an issue. And you can have a look at that case. All right. So like we said before, South Africa doesn't examine. So the first time a patent is actually going to be stressed is the first time a third party can actually have a go is after the grant of the patent. And hence, that's what revocation is all about. Revocation is provided for in section 61 of the Act. So I'll just get up 61 here. And what's interesting about section 61 is that it says these are the reasons for revocation and these are the reasons for revocation only. So it is exhaustive. And to be fair, there's loads of them. I think there's GHI, so 1, 2, 3, 4, 5, 6, 7, 8, 9 ways that you can have a go at a patent, but that's it. So it's exhaustive. No other grounds of revocation can be relied upon. And the case there is Busby, but I don't think it's a particularly important case. I mean, it's like, okay. Interestingly, if you're revoking a patent, and this is just something of interest, is that, say the patent was granted in 2010, and then there were some patent amendments in 2015, and you apply for the revocation of the patent in 2020, you revoke it not on the law that happened in 2015, you revoke it on the law that was in place when it was granted. So it kind of brings its law with it. A patent can only be revoked in terms of the law under which it was granted. In other words, where the Act has been amended, the Act before amendment will apply to those patents and patent applications filed before the date of the amendment. Okay. It says there, unless the amendment is favorable to the applicant or the patentee. I'm not too sure about that. Yeah, that's a new amendment, but anyway. What case was he saying? 61 E and G. All right. Okay, cool. All right. So any person can apply for the revocation of a patent. It doesn't have to be somebody who's being sued under the patent. It can be, just an interested party. So section 61(1) starts off straight out of the gate. Any person may at any time apply in the prescribed manner for the revocation of a patent on any of the following grounds only. So it's that only, which makes it exhaustive in terms of Busby. Any person may at any time. So now why? So at any time. So that means that you could revoke a patent after it's actually expired, after it's served its 20-year term. You could still revoke it. And the reason why you might want to do that is because when you revoke a patent, it's like it never existed. Okay, it's not like it existed until you revoked it. It's void ab initio. So if you've been paying license fees or something like that under this patent and it suddenly poof gets revoked, then you will have paid license fees on nothing for all those years. So you would try and get those back. What would you argue in that case to get your license fees back on a revoked patent? What do you think as lawyers? What would your advice be?
If something was void and ab initio,
Yeah,
it means that it never existed.
right.
That means that whoever was getting the license fee, it was unfair enrichment.
Exactly, exactly. Unjust enrichment.
Yes.
That's what you go for there for. Yeah. See how it works. So, we bring other areas of sort of civil law into it. But that's right. I'm just so yeah, unjustified enrichment, and that would be going for a patent which has expired is nevertheless capable of being revoked because revocation dates back to the date of grant of the patent, and therefore revocation can affect claims for infringement or for royalties, and that is Wright, Bogue, and Head, Wrightson. So that's pretty clear on the face of it.
So, Prof, can I ask you something? Before the court actually revokes your patent, do they give you the opportunity to correct or
Yes.
amend the patent?
They do. So the court will bend over backwards to accommodate you. Yeah, definitely. So, and then what you'd be doing is you'd be looking to amend your patent, and that would be section 51(9), which we spoke about last week, which would be application to amend during the course of litigation. Tricky. A fight, a huge fight all on its own. But yes, before revocation, it's almost always you're given the opportunity to amend it if you can. And that would be by sort of limiting the claims. Okay. So, yeah, okay. So if you think of a claim, so when you draft a patent application, so you're going to have to bear with me now because I'm going to use a chemical example, all right? But in chemistry, I know you didn't do it. We'll start very basically. You get carbon and you get carbon chains. Okay, so sometimes, and the carbon, they just join like that, right? So if you have 4 carbon chains like that, then that's known as a C4. Okay, if you have 3 carbon chains, it's known as a C3. Okay, say your invention needed a C2, just 2 carbons like that. Okay, but you would claim a C4 because a C4 includes a C3 and C2, right? Because it's broader. So if you say up to 4 carbons, you can have 4 carbons, 3 carbons, 2 carbons, etc., etc. So then, if you think about your invention, what the guy came to you and told you on the day was a C2, okay? But you say, no, I think we need to expand that a bit, yeah? So you make your claims to be C3, and then you make your claims to be C4, right? So your broadest claim is a C4. So and that's your claim 1. So you say a C4, well, you just say a molecule including up to C4. Right, because that's your broadest one. Then your second claim would be a molecule as per claim 1, including up to C3. Okay, and then your third claim would be a molecule as per claim 1 or 2, wherein it is C2. Okay, so you can see how we're bringing it down like that. So when you are arguing whether that claim is valid or not, you'd be looking at prior art documents, which is to say documents that existed were in the public domain on or before the priority date of the application, the first date on which you applied for it, which taught any of these molecules. If you've got a document which describes a C4 molecule before the date on which you filed for this patent, you're dead because you're anticipated, right? But what tends to happen in practice is that you might find your opponent might find a document which describes C4, but doesn't describe C3 or C2. So what that means is that your first claim is anticipated, but your second claim and your third claim are okay. Okay, because the prior art only describes C4, doesn't describe C3, doesn't describe C2. So what would happen in that case is that a judge would say, claim 1 is invalid. It's anticipated by the document which describes C4. Therefore, all of your claims are dead. Okay. But if you say, oh, my lord, how about I just delete claim 1, and then my claim 2 becomes my claim 1, and then I say a molecule, and I just delete that as per claim 1, including up to C3. That's novel. No, C3 is not taught in the prior art. C4, I acknowledge, is. C3 isn't. C2 isn't. So that claim is dead. That's fine. These claims survive. And that's what happens in practice, right? Because the prior art is often not a direct hit. It's just taking out this outer ring. Okay? So it's like the skins of an onion. And if you are peeling an onion and the outer skin has got a brown mark on it, you don't want it, you just take it off and throw it away, and the rest of the onion is fine. That's exactly how patent claims work. They're broad and they get narrower and narrower, and the invention lies at the center. That's how we do it. So now, unfortunately, we've got 68, which says that one bad claim, the whole patent is not enforceable. Okay, one bad claim.
I just want to understand now, if the C4 claim goes away, it means that you do acknowledge that maybe you didn't invent it. It's not patentable.
The C4, but the C3 and the C2 is.
You will say, no, my lord, I've invented this, as a result, it is patentable.
Yes.
That's what you say.
Yeah.
Okay.
Not C4. I acknowledge, I see. My learned colleague over there is quite correct to say that C4 was already known when I filed for my patent. But nobody had thought about C3. Nobody had thought about C2. I deserve the fruits of my labor when it comes to C3 and C2. So C4 was known. I can't claim any monopoly to that. That claim must go. But the rest of the claims, my lord, are good.
This is basically to say that in a patent, some of the parts of it can be revoked.
Yes.
You can, oh, okay.
Okay, so, but here's the rub, which is what we're getting to. One bad claim, it taints the whole barrel. One bad apple in the barrel, the whole barrel is no good. Okay, you can't then assert infringement of the remaining good claims unless and until you amend it to take away the bad claim. You've got to reach into that barrel, take out the bad apple, throw it away. There can be no bad apples in the barrel, all right? So if you've got a single bad claim, you've got to amend. And then you're amending in the course of litigation 51.9, and the first thing that the other side is going to do is oppose it, right, in terms of 51.9. So you've got a battle on your hands. But the fact of the matter is, if you don't amend, okay, to the point to delete that, your whole patent is bad, okay? It gets revoked in toto. So you have to, if one claim is found bad in revocation proceedings, the whole patent goes down unless you can amend to a position where you've got some valid claims left. So it gets tricky very quickly. And that's why, you know, you've got to, the courts bend over backwards. They say, I'm minded to revoke this patent because you've got a bad claim, but I will give you the opportunity to amend it before I make my order final. And then, but then of course, it's not like you just go away in a minute. It just leads the parties through to another battlefield, a 51.9 battlefield, where they're trying to amend, and that amend gets, and now this brings me, I'm jumping around a bit, but I want to put it in context. This brings me to one of those aspects that I was talking about this morning. South Africa doesn't amend, doesn't examine. So we've got a couple of things in our act which compensate for that, right? One of them is the 9 months thing. Section 68, which I'm talking about, Section 68 says you can't enforce a patent that's got one bad claim. Okay, that's quite an unusual thing in the law, and it's to make sure that patent proprietors keep their claims valid, okay? Because there are a number of places in the Act, at least 3, which says the conduct of the patentee will be taken into consideration in allowing the amendment or not, and allowing costs and damages or not. And what does that mean? The conduct of the patentee will be taken into consideration. My advice to you, get up an electronic copy of the Act and search for that word, conduct of the patentee. You'll see it pop up a couple of times. And what it's saying is, and there are a couple of places we're doing, and it's one of my favorite exam questions, just saying, is, okay, so you know that when we were talking last week, we were saying that, you know, you start off with, you know, your first application, then you file mostly a PCT, then it goes through the international phase, and then it splits out into all these different corresponding. So you'll have a US invention, you'll have a Japanese, you'll have a Canadian, you'll have a European, you'll have a South African, you'll have an Australian, and so forth, right? Okay, so your single invention splits out into all those different countries at the end. So now what we're talking about is we're talking about the South African one, right? Because we're here in South Africa talking about the South African Act. But we live in a global village. So the first thing I tell my clerks to do, ask my clerks to do, is if I'm fighting somebody, I say, what happened in Europe on the corresponding case? What happened in the US? Notoriously difficult jurisdictions to get patents because they are examined, okay? So if he made hectic amendments in Europe and he hasn't made corresponding amendments in South Africa, that's not good for the patentee, because I can say to him, my lord, he knew very well that that claim was not valid, and he knew that because the Europeans had told him that when he tried to get his patent in Europe, and he agreed with them because he amended that claim in Europe, and yet he chose not to do it in South Africa. So he has willingly, with willfulness, held an invalid patent against me in South Africa, and he knew it was invalid. And the judge will say, I agree, that's very naughty. I'm not, and in the worst case scenario, I'm not going to allow him to amend, or he can amend, but he gets no damages and he has to pay my costs or something like that. So the judge has a lot of flexibility based on the conduct of how long did it take him to amend a South African patent when he knew very well all along, more often than not as a result of corresponding applications, that it was invalid in South Africa. So the conduct of the patentee is a very important aspect in damages, costs, and allowability of amendments. So just I would really do that. Interestingly, just a word on these offices, okay? And stop me if I've told you, I'm getting old, so I can't remember what I said. I confused the lectures, but the European Patent Office has thousands of patent examiners, right? And they're all specialists in their different areas. So you've got a guy on golf balls, you've got a guy on fertilizers, you've got a guy on paints, you've got a guy on pharmaceuticals, you've got hundreds of guys on pharmaceuticals, you've got guys who are working on HIV, you've got guys who are working on heart attacks, you've got guys who are working on epilepsy. And so whenever your patent comes, they will look at it and say, oh, Denayo's patent on golf balls, that goes to John in Office 54C. And there I sit, and I'm an expert on golf balls. I've seen every patent on golf balls that exists. And I'm the guy who says, you've got something inventive or not, you know? So you've got this really, really good examination, very thorough. And the same for the US, Japan, you know, they're all really, really good. But EP and US are the two big ones. To be an EP examiner is quite a cushy life, okay? You don't pay tax. You get to live in Munich or The Hague or Vienna, somewhere nice. You knock off every day at 3 o'clock. You only do one case a week. Yeah, so, and you know, you get paid in euros and pretty good money. So yeah, to be a European examiner is quite sweet. And as a result, they are very nice guys. So when you speak to the examiner, he's probably in a good mood, right? Yeah. Because he's going skiing that weekend or whatever. So, and if you are polite to him, he is very polite to you. And so we can get things done in Europe just by having a lot of mutual respect, right? So like you can say to a European examiner, if he says your claim is bad, you can say to him, okay, thank you very much. I accept your opinion. do you have any suggestions as to how I can make it good? And he will come back and say, well, yes, if you say this, I'll be happy to allow it. That's very unusual. US examiners just tell you to get off. They just said, claim's bad, I'm not interested. No, it's not my job to tell you how to make it good. Come and try again. And every time you write to a US examiner, you have to pay the US PTO fees. Whereas Europe is a lot more, we can have a lot more back and forth. They're very easy, but the US are like super parat, like you write one letter. If I say no and you want to write another letter, then you must pay. And so it goes. So it's very expensive to get a US patent. Also, the US patent, they're so big that they can't have one campus for all of their guys, right? Because it's just massive. So a lot of US examiners work from home. A lot of US examiners, believe it or not, because immigration to the US is so huge, English is not their first language, believe it or not. These guys are Korean, these guys are Chinese, these guys are Indian. And so you are having a conversation with somebody who's not being supervised properly because he's not in the office, he's working from home. English is not his first language. And yeah, so their understanding is not as incisive as the European. It's much more difficult to get a patent in the US because you, believe it or not, have this language problem and you have this lack of supervision. So in Europe, they all work. They've got a beautiful building in Munich where they all work. And it's massive. And it's very collegial. So they pop into each other's offices and they talk and they say, what do you think about this? So it's a lot more reasonable approach. Whereas in the US, they all just work in their little silos at home. And as a result, the quality of examination, the quality of substantive examination varies wildly in the US, whereas that is not the case in Europe. But again, I digress. So basically, what is that? Because what happens in Europe has a bearing in South Africa, because if they don't introduce the same amendments that they introduced in Europe to get a granted patent, they've got a big problem when it comes to convincing a judge that they acted in good faith. So that's an important aspect of it. So that conduct of the patentee is a super important phrase. And you can see it if you look at section 68, which we will get to. So he's talking about the judge. In exercising his discretion, he may take into consideration the conduct of the patentee in inserting in the specification those claims which have been found before amendment to be invalid and or permitting such claims to remain there. So you can see that the Act says specifically, if you've been a naughty boy, you mustn't expect relief. So that is a very important aspect of the Act, which seeks to compensate for there not being compensation, right? Not being examination. Okay, so now let's talk about the actual grounds for revocation. And I'm not going to really go through them in a lot of detail, but there's a few of them which are more important than others that I just want to kind of draw your attention to. So I'm going to be working quite closely from the book, and and just sort of like highlighting areas which I think are interesting. So the first reason is that the patentee is not a person entitled under Section 27 to apply for a patent. So when we did lecture 1, we said who's entitled to apply for a patent, and it's only 2 people. It's the inventor or a person who has acquired the right from the inventor. So if it's anybody else who tried to apply, so what does this mean? This basically means you're going to go through the paperwork, and if you can't find a valid, if it's not the inventor, and it's another person, and they can't show a deed of assignment which transfers the rights to apply from the inventor, he's got a problem. Okay, he's dead in the water. So the persons who are entitled to apply are dealt with in paragraph 5.3, and it's basically the inventor or a person who acquires the right to apply. A second reason, the grant of the patent is in fraud of rights of the applicant or any person. So Botha versus Lindeque is the case, and it's really when there's been sharp practice, when there's fraud. The grant of the patent was in fraud of the rights. So in other words, there's been a misrepresentation, or fraud is construed as conduct on the part of the applicant that is deliberately, intentionally designed to deprive the true proprietor of his rights. Accordingly, fraud in this context does not refer to the criminal act per se, but rather dishonest conduct by a party. So that doesn't happen very often. Water this Linda Q, I think is, I'm just going to turn the aircon down a bit, getting up the sweat here. Let me know if you get too cold. It's really not common. The fact that there's only one case on it speaks volumes. Okay, the big one, the one that everybody fights about, Section 25, not patentable under Section 25. And what does that mean? It's not an invention. So what are the things that are not inventions? Methods of treatment, etc., etc. It's not new, which means it's been anticipated. It existed in the art before the priority date. Does not involve an inventive step. All good things like that. It's not capable of being used or in trade, industry, or agriculture. Encourage offensive or immoral behavior. It's a variety of plant. It was used secretly and on a commercial scale. It's a method of treatment of the human body. Okay, so, you know, that's basically, it's Section 25. It doesn't comply with Section 25. But what I want to deal with quickly now this morning is the difference between inutility and insufficiency. This is a tricky one, okay? This is a tricky one. Because if you look at a patent and you consider a patent from a philosophical point of view, okay, the whole reason you're getting the monopoly, the whole reason you have the right to exclude others from practicing your invention is because you're teaching us something new, right? So before you came along with your patent application and your solution to this problem, we didn't know how to fix that problem, and you have solved it for us. But if your solution doesn't work, then you shouldn't get a patent for it. If it's in Utah, then it's not, it doesn't work. So, for example, if the invention cannot be performed, then, you know, say, for example, if you say in your specification, you get a 50% reduction in pollution output, and you don't, you get a 48% reduction. You said 50, and now I'm only getting 48. I can't get 50. If you had said 45 or 48, that would be fine, but you said 50, I can't get 50, doesn't lead to the results as set out in the specification. That is a ground for revocation. So now, obviously, as a patent attorney, you have to be very, very careful about what you say this patent can do. So you must make sure that the invention can, in fact, be performed, and that it does, in fact, lead to the results or advantages set out in the specification. So this may arise where the patentee makes a promise in a specification which cannot be met. So you can rely on these when applying for the revocation. But the whole thing about utility is the whole thing doesn't have to work. Okay, if you revoke it, if you're trying to revoke it on utility, it's quite difficult, because if you can just prove a little part of it works, then that's still okay. It's enough to save the patent. So only a small quantum of utility is required. Thus, if a patentee can show that his invention works and leads to the results or advantages as set out, even in some of the examples or drawings, the patent will not be revocable on this ground. So that's important. Okay. Okay. So that's inutility. It doesn't work. It doesn't lead to the results that were promised in the specification. The other one is insufficiency, whereby the patent can be revoked if it does not sufficiently describe, illustrate, or exemplify the invention and the manner in which it is to be performed to enable the invention to be carried out by a person skilled in the art of such invention. Now, I want to draw your attention to the wording. That is section 61(1)(e). A person skilled in the art. Okay. So if a person can't do it, but artificial intelligence could, then you're still liable to be revoked, because insufficiency is based on the skill level of a person. So basically, your specification in and of itself should enable somebody who's got the skills in that particular area to take your invention and put it to work, just like that. It should be a recipe. Everything he needs should be in the patent application. If it's not, then it's insufficient. If he has to go and invent new things or have reference to other books, then there's a very good argument that the invention has been insufficiently described. So essentially, one needs to ask, does the specification contain proper instructions for enabling a person skilled in the art to put the invention into use? If the answer is yes, then the specification is sufficient. On the other hand, if the answer is no, the specification should be regarded as insufficient and the patent is liable to be revoked. So it's like, is this a cookbook? Does this in itself, without having reference to any other books, give me what I need? Yes, it's sufficient. No, it's insufficient. It's liable to revocation. Okay. Right. So that's that. Ambiguity and fair basis. A patent may be revoked if the claims on a complete specification are not clear or are not fairly based on matter disclosed in the spec. So let's talk about fair basis. So you will recall that I said patents are always built on the same skeleton, okay? Every patent starts with an intro. Okay, it talks about a problem. So the intro is this invention relates to bicycles. In particular, this invention relates to painted bicycles. The problem is that red bicycles are very common, but red bicycles are easily seen, and red bicycles are accordingly stolen a lot. Then comes the description of invention. Then comes, I'll get to these, well, actually, it's a summary of invention, which comes out. I should know this. I've only been doing this for 30 years, but anyway. Summary of the invention. The detailed description. Then comes the specific description. I'll tell you what all of these are. Then comes examples. Then comes claims. Claims, of course, are the most important part. And then at the very end is an abstract, which is only for searching purposes, doesn't have any legal bearing otherwise. Okay, so every patent is drafted along those lines. Okay, it's got those. Intro relates to bicycles. Problem, red bicycles get stolen. The solution to the problem, the summary of the invention, is to paint the bicycles green. Detailed description. By green, I mean any one of the following Pantone references. Yeah, you remember this from that lecture, right? Specific description. I took a Rally X3 one. It was painted red. I bought Pantone reference from Plascon, and I painted it, and that's how it works. Example was, we did an experiment on the Isle of Wight. We released 100 red bicycles and 100 green bicycles. After 6 weeks, 50 red bicycles had been stolen, but only 10 green bicycles had been stolen. Goes to show that the summary works. Claims, a bicycle which is painted green, a bicycle according to claim 1, which is painted green according to the following Pantone reference, etc., going down like that. And then abstract, this invention relates to green bicycles. This ground for revocation says that the claims are not clear, and secondly, the claims lack fair basis. So if the claims should echo word for word what goes on here in your summary of invention and or the detailed description. So if suddenly you're talking about green bicycles, data, green, Pantone reference, X to Y, etc., examples green, and then you suddenly say down here, and the bicycle is purple, like everybody's, what the hell? Where did purple come from? There's absolutely no basis for purple here. Okay, so yes, green, no worries, but purple, you're completely silent on that. There's no basis for that in the claims revoked. So whatever you claim in the claims, you've got to talk about in the rest of the specification. So that's the fair basis application. Clarity. Well, clarity in the claims. It's like a nightmare because you know what's clear to one person is not clear to another. But there is some case law in South Africa which is clear, and that is you can't use words like sit down for this. You can't use the following words in the claim. Preferably, preferably, in particular, such as, for example, and so forth. Any of those words in a claim render the claim unclear. So you can't say, for example, say your claim talks about cars. So you can say a car which is blue. So the claim would be a car which is blue. Okay. But some people would like to say a car, preferably an Audi, okay, which is blue. So that claim is good, that claim is bad for clarity, okay? Because somebody comes along and says, preferably, what the hell? What does that mean? I've got a blue BMW. It's a car, but it's not an Audi. But you say it should preferably be an Audi. So does the BMW infringe that claim or not? And the answer is it's too difficult to understand. If you wanted any car and all cars, then it should be just a car, which is blue. And if you want an Audi, you must say a car, which is an Audi and which is blue. But to say preferably, and any of these other words, a car, in particular an Audi, a car such as an Audi, a car, for example, an Audi, which is blue, those are all bad for lack of clarity. It's just claim drafting. But that's a ground for revocation. Because it's all based on the same idea that you're telling somebody what they can't do, right? You're being prescriptive in your claim. You're claiming this area of technology for me. So it has to be crystal clear what others are not allowed to do. That's the whole idea behind patents. And that's why there's such a big sort of effect of getting it wrong or being unclear in not defining your monopoly. If there's any argument about what a person is not allowed to do, the court will find in favor of the person who's not allowed to do it. They will grant them the benefit of the doubt. So you want to make your claims as clear as possible, and hence that being a ground for revocation, ambiguity, and fair basis. So Gentiluca versus Firestone, that is the most horrendous case. I think I've told you about that. I wouldn't advise you read it, but because it requires the patience of Job to get that right. But if to the extent it's quoted in the book, it's really good. Because they talk about how in a specification you can create your own dictionary and you can give words their own meaning over and above their ordinary dictionary meaning. So you can say in the specification, glass means, you know, black glass. And when I speak of glass, I mean only black glass. And so you can, you know, you can manipulate it because it's like a little world in itself, right? The specification, it contains everything that you need. So as long as it's fair and as long as it's clear, you can define things how you want them defined. And Gentiluca goes into some detail on that. And that's been sort of held up in the UK courts as well. It's kind of like a harmonized concept around the world. Okay, the last one. Okay, there's two more things I want to talk about. What are we? 11:30. We're doing well. false statement or representation, and then partial validity. I'll talk about that at the end as well. Okay. False statement, there are two forms which need to accompany a patent application in South Africa, which are what's called declarations. And declarations are really important because they're like affidavits. If you declare something and it's wrong, you're in a problem area. So the two forms are the P3 and then the form P26. So the first is there was an amendment in 2007 which made it even more difficult for people to get around it. But basically, if on the P3 you declare a whole bunch of things, you declare that you have the right to apply for the invention, you declare that the inventors are correct, and you also declare that this is based on a single priority. If you get any of those wrong, it's liable for revocation. You've lied on a declaration. It's fatal. Okay, it's just one of those very unforgiving sections in the Act. But the old Act used to say, which the applicant knew was wrong at the time of signing, and that gave them a little bit of wriggle room because he could say, well, I didn't know that he wasn't an inventor or whatever. But in 2007, they introduced the additional wording, or ought reasonably to have known. And that changed everything, because then you can't argue, well, I didn't know, because now you should know. You should have made inquiries about who the inventor is. You should have a reasonable person would have made inquiries about whether this is in fact the first application from a priority application, etc., etc. So it's become a lot more onerous on that. And so a false statement or representation on a P3 strikes fear into the heart of an applicant, because that is the silver bullet. So that's the P3. The P3 says, I'm the applicant, I've got the right to apply, these are the inventors, it's the first application that we've made, all good. P26, now this is an interesting one, okay. P26 was also introduced in 2007, and this is made in terms of the Biodiversity Act. And the Biodiversity Act in South Africa is designed to protect indigenous resources, okay? So basically what the Biodiversity Act says, and the amendments to the Patents Act, and we will talk about this again in a lecture or two's time, is that if the invention involves any South African fauna or flora, plants or animals or anything like that, any indigenous biological resource, you have to have a benefit sharing agreement in place with the community where that indigenous resource grows. Okay.
You must have what?
A benefit sharing agreement. Okay. So let's talk about a couple of South African resources. How many of you guys have heard about a plant? It's actually a cactus called Hoodia gordoni. Hoodia gordoni. You guys never heard of it? Oh, this is an awesome story. Okay. So here we go. Hoodia gordoni is a type of cactus. That's the name of the species. It's just called Hoodia. Okay, that's how we talk about it. And it was known to the San people for years and years and years that if you ate some of this cactus, you didn't feel hungry anymore. Okay, so it's called a satiety agent. Even though you have got nothing in your tummy, when you eat this cactus, you stop feeling hungry. It's like a chemical. There's a chemical in this thing. So for the San, this was awesome, because you could hunt for days and your tummy wasn't rumbling and to scare away the buck. Hoodia gordoni. It's discussed later in the book. I'll give you the reference, but we do talk about this. Where is it? Traditional knowledge. So on page, I'm just waxing lyrical about. There we go. On page 339 of the book, it says their case studies, Hoodia. Okay, I'll read it. The San people are known to have used the bitter flesh of the Hoodia plant, Hoodia gordoni, for centuries to block feelings of hunger and to give them energy. the CSIR, the South African Council for Industrial Research, began taking an interest in the properties of hoodia, and the research resulted in the isolation of an active ingredient and investigations into its properties and its potential as an appetite suppressant and anti-obesity drug. Okay, so what does that mean? Okay, so the SAN, the people of South Africa, have been in possession of this knowledge for hundreds of years, right? They've been using it to not feel hungry for ages. They used it, while they were hunting because it was beneficial then. Now along comes the Western world, and obesity is a big problem. But now, if you can take a pill and you don't feel hungry, you don't want to eat, you'll lose weight. So the potential to use hoodia as a weight loss and market it in America was enormous. Okay, but you're using something which the SAN people have known about all along. So it's not fair that these Westerners come along and just say, I'll have some of that, and then they make a lot of money in America with it. So that's why this section was introduced, to say if you're using a South African resource, a plant that grows in South Africa, then some of those profits need to come back to the community. And you would conclude a benefit sharing agreement with the SAN people. So that's kind of how it works, right? And there are lots of other examples. Rooibos tea and rooibos tea, honeybush, and then there's another one, pelargonium, which I'm not particularly familiar with. But I know hoodia and I know rooibos or honeybush, which makes great tea, right? Rooibos, so hoodia sadly came to nothing. I don't know why, but the SAN Hoodia Benefit Sharing Trust has been established. The primary objective of the trust is to ensure that any monies received are used for the general development and training of the SAN community. But so they did set up all the benefit sharing agreements. They set up a trust to receive monies, etc., etc. But for some reason, hoodia never really took off around the world. I don't know why. It's just one of those commercial realities. On the other hand, rooibos tea is hugely popular everywhere around the world, right? And so when I go to England, my English friends say, oh, would you like a cup of red bush tea? And I'm like, you mean rooibos? So like it's on the shelves at wherever, and that gets a lot of money for the communities that grow. I think they're down in the Eastern Cape, and the rooibos communities they get a lot of money. So it can work. Interestingly, on hoodia is quite a story actually, because the SAN obviously knew it for a long time, but then in apartheid South Africa, the army, the South African Defence Force, were very like they had guys who could live in the bush for years and years and years. So what the army did in the 60s and the 70s was they catalogued every plant in South Africa and what it was good for and what it wasn't good for. So, like they said, if you're in the bush and you don't have anything, you can eat these plants. You can, if you've got a headache, you can chew the bark of a willow tree and it's good for, a headache. If you've got a cut, rub this one on. Basically putting all the knowledge that all the communities around had in a book so they could train their soldiers when they went out there. And they figured out this hoodia thing. I think they chatted to the SAN and they said, why do you guys eat that? And, they figured it out. And then they gave that information to the CSIR, which is just down the road, and they actually isolated the chemical compound from the plant. And then they synthesized that chemical compound. They made it without having use of the plant, right? They sort of built it in the labs. So now you've got all these things about, well, so the name of the compound is called P57. That's the compound which, so when you eat this, it doesn't actually fill your tummy. It's just this P57 compound goes into the blood and tells the brain you're full, okay, even though you're not. So it's like a drug, but it's a natural drug. So the question remains is, okay, well, what about the guys who synthesized P57 for the first time? They're not extracting it from the plant, they're actually making it in the lab. should they get a patent for it? And if they do get a patent for the synthesis of P57, should anything go back to the SAN community? Because on the one hand, they've got nothing to do with the SAN community. They are making it in a lab. They don't have to go and harvest the plants from the SAN community lands or anything like that. They're just in a lab making this stuff. And on the other hand, you say, yeah, well, but for the SAN, they wouldn't know about it. So, they're standing on the shoulders of giants. So these are all arguments which exist around these natural resources. But the bottom line is, man has been using plants as to get medicine for years and years and years. Earlier, I mentioned chewing on the bark of a willow tree for a headache. That's because willow trees make disprin. Okay. Well, they make a chemical compound called acetyl salicylic acid, which is the active ingredient in disprin. And that's how they found disprin, is by saying, when I chew, if I've got a headache and I chew the bark of a willow tree, then my headache goes away. So then they extracted the chemicals that were in the bark of the willow tree, and they said, oh, it's this one, acetyl salicylic acid, and that's how it worked. Interestingly, I'll tell you a story about disprin. Okay, so the company, they found that out in the late 19th century, 1890 or whatever. But the thing about, so it's the chemical compound is called aspirin, all right? But aspirin is not dissolvable in water. If you take pure aspirin and you put it in a glass of water, it goes yucky. You get like this white scum on top, and it's horrible to drink. So you could only take disprin as, well, they didn't have disprin, they only had aspirin. And you just took it as a pill, and then your headache went away. And so many people were working on the problem on how to get aspirin to dissolve in water. Okay. One of the companies that was working on it was a company in England, and so England is, it's kind of shaped a bit like that, right? That's really bad. London is there, Ireland is there, Europe is here, okay? And over here is a huge river that runs into the sea, okay? And there's a town there called Hull. And then in the middle, you've got Leeds. And then over here, you've got Manchester and Liverpool. Okay, they're all in this line that runs across the middle of England. In the Second World War, the German bombers would fly from Germany over here, and they'd fly over the English Channel. And when they saw this big river mouth here, they knew that if they just flew directly east, they would find Manchester, Liverpool, and Leeds, which were big ports, and they had big factories there where they're making tanks and everything. So they would fly over and they would bomb the hell out of these areas and then fly home again. But England, it rains a lot, right? So often these targets were obscured by clouds. So the German bombers would fly over and then they couldn't find their target. So they'd fly around, but the cloud cover was low. Then they'd have to start going home because, they were running out of fuel. But they're not going to take their bombs home with them, right? Because it's, it's unsafe. You don't want to land with a belly full of bombs. So they would just drop them on Hull before they left. There were no targets in Hull, but it was Britain, and they were there to bomb Britain. So Hull just got absolutely hammered in the Second World War, absolutely flattened. And one of the factories that was there was a factory that was trying to figure out how to make aspirin dissolvable in water. And this company made starch, okay, because back in the day, starch was used when you washed shirts to make them stiff and to make your collars stand up, right? So starch was big business. So this factory made starch, and it also made aspirin, okay? And then one day the factory was bombed by accident because the Germans were going home. And so the starch labs and the aspirin labs had to share space. They had to share a room because one of the rooms was bombed. And there was a cross-contamination completely by accident. Somebody took a bowl of starch and added it to a bowl of aspirin because they're both white powders, right? So this lab tech didn't know what he was doing. He added starch to aspirin, and lo and behold, when he added water, he found that the starch disperse the aspirin in water. And so that's why you get, if you combine the words dispersible and aspirin, you get dispirin. And that's the dispirin we know and love, huh? That's what we've been taking all of these years. Aspirin and starch together, 50-50. And then you get dispirin because it's dispersible in water. Because you know, when you were a kid, you didn't like taking the tablets, your mama had to put it in a glass of water first. Huh? So we don't give dispirin to kids anymore because of Ray's syndrome. It affects kids, but certainly my age, I grew up on dispirin, and yeah, that's how it happened. It's still sold in shops, yeah. But it does say you shouldn't give it to kids under 10, because very low percentage, like 1 in 10,000 or whatever, but still too high for comfort. You get something called Ray's syndrome, which affects their ability to learn later in life. That's why, you know, the medicine, I know none of us here have kids. Nobody's got kids here.
I do.
Oh, do you? How old is your kid?
I have 3 kids.
Oh, fantastic. That's awesome. And you're doing this.
Yeah, but
Wow.
16, 12, 4.
And 4. Okay. So your little 4-year-old, do you give him Calpol? That purple stuff when he's running a fever or something like that?
The pink one.
The pink one, yeah.
The syrup.
Yes.
Yeah.
Yeah. So that medicine has got ibuprofen in, and it's a different drug to dispirin. So that's why they say that you shouldn't really give kids dispirin. You should rather give them Calpol. But anyway, that's what they say. I had dispirin my whole life and I'm fine. I think. I don't know. Okay, so that's a good invention. That's I don't know how we got on that topic. Aspirin comes from the willow tree, and so we expect that all the plants in South Africa will in the future yield a lot more medicine. That's right. We just haven't had the opportunity to really look at them closely, but it's coming. And that's why we have the form P26, which says that if you're working with a South African plant or a derivative of a South African plant, you have to declare that it's South African to make sure that the local community shares in the revenue. If you lie on that form, if you lie on the form P26 and you say it doesn't come from South Africa and it does, your patent will be revoked here, because it's very important that all of this comes back to the people who knew about it all those years ago.
So, Prof, does it mean that whoever that invents, let's say, a particular pill to cure whatever, if the plant is from a certain country, those people need to declare that whatever ingredients that they used, it's from a particular country, and they must give some share. What is it?
Yes, benefit sharing agreement. So we'll talk about that later. So if you say on your P26, yes, it's a South African resource, then it says, okay, go to question 2, show me the benefit sharing agreement. Or so you have to provide proof, not necessarily a benefit sharing agreement, but you have to provide proof that you're engaging with the community and that a provision will be made for the community. You also have to provide proof, I think, and we'll get to this in a lecture or two's time, that you had permission from the South African authorities to conduct research on that material anyway. So it's quite highly regulated because, you know, we're very aware of neo-colonialism, you know, where the rich Western companies just come in, rape our resource, take what they want, and then leave, and nothing comes back. So that's what the P26 is all about, to make sure that that is not happening, and the Biodiversity Act. And we will talk about the Biodiversity Act in more detail later. Okay, yeah, so that was false statement or misrepresentation. We've spoken about frivolous, immoral, illegal inventions, nuclear inventions. Anything to do with nuclear has to go to the, it's got to be declared to the NECSA, the Nuclear Energy Corporation of South Africa. You can't claim an invention which is against the laws of science, a perpetual motion machine or whatever. You can't get an invention for something immoral. So you can't get an invention for an instrument of torture. You can't get a patent for how to make a letter bomb or anti-personnel landmines or anything horrible like that. And again, that's the basic philosophy of it. The Patents Act is there to help society, to solve problems, to give us a better headache pill, to give us a COVID vaccine, not how to torture somebody. That's not in anybody's interest, that we have better ways to build letter bombs, better ways to blow off somebody's foot. Nobody wants that kind of technology. Is not encouraged. The Patent Act is not there to encourage immoral behavior.
So if it doesn't, you can, what, the invention of instrument for torture, wouldn't a gun be part of that, or is just a protective one?
So guns are interesting because guns can be used for good or for bad, right? Okay. Yes, most crimes are committed with guns, but people also use them for defense. We need better, stronger guns for our army to defend our country, etc., etc. So a gun per se is not a bad thing, but it's a very good question because there are certain armaments which are just not lacquer. And so examples of things which are will not be patentable is like bullets that are designed to fragment and basically shred the person when they get shot. That's not why do you want to do that? You know, a bullet is sufficient. If you get shot with a proper bullet, you stop. You don't need to, you know, shred the person. That's not necessary. Landmines for tanks, fine. You need a landmine that will blow off the track of a tank and stop it. But you don't need a little itty bitty landmine that's just going to blow off somebody's foot and maim them. Why do you want to do that? That's you know, you're going to leave it there for kids. So landmines, particularly anti-personnel landmines that are designed to maim individuals, not cool. Big ones to blow up trucks and tanks, fine. Kids won't set those off. But kids, animals, you know, they're horrible little things. They're the size of the teacup, and they're just designed to blow off a foot. Not cool. So those kind of things will not be protectable.
Still manufactured.
Yeah. People still make them all the time. But there's no, given that the Patents Act is based on an encouragement, right? To say, if you do this, you can stop others from making it, you get all the profit from making it. If you want to make something horrible like that, then, you know, it's up to you. We're not going to give you any protection. We're not going to facilitate a monopoly. We're not going to allow you to make a profit off it or anything like that. So that's the plan behind it.
Can I be excused for a while?
Does anybody? Oh, it's 12 o'clock. There's just like 5 minutes to go through when we get back, and then we. So, have you guys enjoyed coming to a law firm today? Has it been helpful to see what's what? How we roll? And do you prefer lectures like this or online?
Physical, but the travel of getting here.
Yeah. If we could all meet in Joburg, that would be better. But unfortunately, I can't get a venue for a Saturday morning, unfortunately. So yeah, either one time. I think what have we got? So the next Saturday is 16th. So we're actually skipping a week. The next time we meet is the 23rd of April. But then we've got 2 lectures, 23rd and the 30th. And then we've got 14th and the 28th of May.
So next Saturday it will be infringement.
What's that, sorry?
Next Saturday, the other Saturday.
Yeah.
will be infringement.
We're doing infringement, that's right, yeah. That's quite a heavy one. General is not too bad. International arrangements is pretty easy. Registered designs is quite heavy. So we've just got one lecture at the end. It's quite a big one. Then The exam is on Wednesday, the 15th, 9 o'clock in the morning. If you guys, so you will see that there are 3 weeks or 2 weeks, a little bit, two and a half weeks between the last lecture and the exam. So if you want to have a revision lecture, you must just reach out to me and we can organize it on the fly, just ad hoc. If you've got any questions, if there's some aspects of what we've been chatting about over the year that you're not 100% about, then very happy to put together a revision lecture. Almost every year, the students ask for a revision lecture. I haven't put one down. It's up to you. But you just say, Prof, can we have a revision lecture? I'll send out a Teams meeting and we're good to go. I think it's nice that we now have a bit of a 3-week break, because you now are in possession of everything you need to write your assignment. So I would encourage you to use, so, you know, we don't have a lecture in 3 weeks time, in 2 weeks time, it's in 3 weeks time, because 2 weeks is Easter. Okay, so that's obviously a big weekend. I'm not going to have a lecture on the 16th, but it does give you 3 weeks to work on the assignment in your own time. Everything you need is, we've spoken about, who's an inventor, why we have an inventor, the philosophy behind it. So I encourage you to do your research, hit Google hard and read all about artificial intelligence as an inventor. Think about it, contemplate it, sit under the sun, and you know, that's what I want to see. I want to see insight. Doesn't have to be just a slavish quoting from the book. I want you to think about it on a philosophical level, and then I want that to come through in your assignment. And then we'll pick it up again on the 23rd. And we were just saying that, you know, obviously I much prefer face-to-face, but
it's insightful to engage. I know it may be inconvenient to some of us who are not driving, but now that we had an opportunity to sit face-to-face, it makes more sense than just to watch on a laptop and somebody talking.
It's very disembodied, really, when I'm just a little picture on the screen.
I actually feel like maybe last year we had this opportunity. Maybe we could have grasped the concept much better. Because this thing of just watching
something else. I think we just passed the grace.
Yeah, I think that's how I feel. That
It was really.
And we would just miss lectures to say, no, there's a recording anywhere, I'll just catch up. So I know it's inconvenient to some of us who are not driving, but these lectures are very.
Well, look, I tell you what, we will. I know there's basketball tournaments as well that can complicate things. I really like getting together with you guys and talking about it. I can look in your eyes and I can, you know, I get a much better vibe on how something is going down. But at the end of the day, it is all about you guys, and I'm happy either way. If we can do it, another one here, that's fine. If you want to do a few more online, and maybe we do the last revision lecture, or we do every second one, whatever. We've got this whole building, as much coffee and tea as you can drink at your disposal. We just have to get ourselves here. And as you can see, I'm very happy to give lifts and things like that. So I'll leave it up to you. I won't be prescriptive as to how we're going to do it. Let's take a break. Let's take 3 weeks. About after Easter, after the Easter weekend, I'll drop you guys a line. I'll set up the appointment, and then we can decide about whether we want to come through together, make some plans, or whether we want to do the next one online. It's all good for me. Okay, guys, let's just knock this on the head quickly. There's 2 things I want to talk about, and then we're going to go. The first is, which we haven't really spoken about, is, do you remember I was talking about how you can genetically modify organisms? Okay, you can genetically modify tomatoes so that they have resistance to beetles, or they can be, they're resistant to frost or whatever. You could also genetically modify microbes, bacteria. Okay, and the most, so, you know, like, a bacteria is like a little packet, and obviously it's tiny, you can't see him. And inside he's got a nucleus, and inside the nucleus, he's got DNA, right? And that DNA makes proteins, okay? The nucleus is like a little machine that makes these molecules. And as a bug, as a bacteria, he's just doing his own thing, you know, he's not bothering anybody. He makes what he needs to survive and replicate, and he does his thing. But what we can do is we figured out that, you know, we have cells with nucleuses, nuclei in as well, and we make our own proteins, which we need, right? All of our cells make those. But sometimes people get ill because they don't make the right proteins. And the best example of that is insulin, right? Now, I don't know if any of you are diabetic or you know anybody who's diabetic, but insulin is required by the human body to use sugar, to break down sugar, okay? If you don't have enough glucose, if you don't have enough insulin, you've got a problem, okay? And you're diabetic, okay? So what people do is they inject themselves with insulin because your cells aren't making it, right? So you get it from somewhere and then you inject it and then you're good. What we can do, what they did was they took a little bit of the DNA from a cell that was making insulin properly. They cut it just like a piece of tape, and then they inserted it into the DNA of a microbe, okay? So now he's got the insulin DNA built in to his DNA. They like literally snipped it in, okay? And now, all of a sudden, this bug doesn't even know it, but he's pumping out insulin because his DNA is going through the making of proteins and everything, and he's just making insulin. And the cell is like, we don't need insulin, so they excrete it. And then, so the solution, the beaker, which these bugs are in, suddenly becomes rich in insulin, okay? That's how they make it, because before, they used to have to kill pigs and get it from pigs. But by introducing that little bit of DNA into that bacteria, you suddenly have an inexhaustible supply of insulin. So the price of insulin went down like this, availability went up, nobody was dying of diabetes anymore. But now, what you've got is you've got a little bug that is genetically modified, okay? That's exactly how genetically modified organisms work, is by inserting a little bit of DNA to do something, to express a type of protein. That's patentable, okay? Because he's a bug, he's a microbe. You can patent him. Okay, you can't patent an animal, but you can patent him because he's only one cell. Okay, or her, I don't know, whatever. But what they say is, if you want to patent him, you have to deposit a sample of him with an international depository. And then they say, okay, sample received from John McKnight, here's your receipt number. And when you write your patent application, you've got to include that deposit reference. So it says here, Section 32.6 deals with the deposit of a microorganism with a recognized depository authority in compliance with the requirements of the Budapest Treaty. The deposit of microorganisms may be required for patenting purposes in order to ensure the requirement of sufficiency as discussed above is met. So in other words, if there's a sample of this guy with an internationally recognized depository, then you've given a microbiologist, who's a person skilled in the art, enough, because he can write to the depository to say, send me a sample, I want to check this out for myself. And they will grow a little bit of these bugs and send it to him and say, here we go. That's what John is claiming in his invention. So you need to deposit a little sample. If it's freeze-dried, and you know, it's not like they're growing in fridges and everything. They're just sitting in all these freezers, and you've got this international deposit, and that's why you can. It tells you by giving that depository number, it's basically giving you the whole DNA sequence and everything you need to know, so that the description is sufficient for the purposes of revocation. Okay, so that is the final reason for revocation, and that would of course only be applicable if the invention related to bugs. Over the page we talk about procedure, and I'm not going to go into procedure because we've all done civil procedure for our sins in our undergrad degrees, and that's basically, it's you know, the Court of the Commissioner of Patents is as per that case. Where is that case, by the way? Oh, there we go. Thanks. Let's get it back. Okay. It's actually just in the High Court in Pretoria. They just allocate a court on the day. It's and you know, somebody might come along and stick a piece of paper saying this is the Court of the Commissioner of Patents for today, but it's not like it has its own building or anything like that. It's just like a name which is applied to a hearing in the High Court, which on any other day is just a straight up High Court, and the judge wears the same robes and everything. Yeah.
You sometimes act as an acting judge.
No, certainly not. No, nobody trusts me.
Oh, no, it's not about you never applied, I'm sure.
But are there any specific judges sitting status? Because I know on trademarks, Judge Harris.
Yeah. And unfortunately, there are some judges out there in the different divisions, which are, well, particularly in Northern Gauteng, which are skilled in IP. And we always hope that they will be allocated as a commissioner. But unfortunately, the recent judge presidents have felt that anybody can do IP. So we just get who we get on the day. And so as a result, the judgments can vary greatly in quality. So, but like most of these, I mean, this is, you know, you'll see a couple of them, Van Dykhorst, and Harms does patents as well. This one is, this is Van Dykhorst as well. So you'll see a couple of the judges come back, but every now and then somebody comes out of nowhere and you get what you get, you know. And it's really difficult because often it's the first time they've had to deal with the Patents Act. So counsel will actually spend the first morning explaining and educating them about the Act and the section and why it says what it does, and this word, that word is very important. It can waste a lot of time, which means arguments are rushed, which means, no, it's not good. So in answer to your question, there are judges who have experience, but they're not always allocated to the Court of the Commissioner. Yeah. Okay, there's another act I want you to read. This is this one. It's the same, Deaton Engineering. This is the very first one. This is a long saga about what's what. This has got a great explanation of 68 partial validity in it. So I want you to just make a note of that reference, pass it around, and I want you guys to read that case because basically this is what we spoke about earlier. Section 68 of the Act specifically prevents a patentee from enforcing its patent if a single claim is found to be invalid. So, where in proceedings for infringement, one claim is found to be valid and infringed, but other claims are found to be invalid, the patentee, the patent proprietor, will not be granted relief for infringement until such time as the invalid claim has been amended or deleted. Okay. And then for this reason, a patentee should ensure that his patent is maintained in valid form at all times, if necessary. And where a patent is found to be invalid, either wholly or partially, it is customary for courts to give the patentee an opportunity to apply for amendment before the revocation order is made final. So we've kind of discussed this earlier. But what I want you to do, I'm going to leave this with you guys today. I want you to read Section 68 before you read the McKelvey case. And then I want you to think about how your interpretation of 68, and then see how Van Dykhorst interpreted it in that act, in that case. Because for me, I think it's very interesting, you know, his interpretation of it. And he did it by comparing the old act, the 1952 Act, and how it appears in the 1978 Act, what bits were left out, and what you can infer from those bits having been left out. And so some people think that Section 68 doesn't actually specifically prevent a patentee from enforcing. It's just an option given to the judge. Other people, like Dean and Dyer, think that it's clear on the face of it and it specifically prevents a patentee. I myself am not too sure. I think there are some cracks in that judgment. But what I would suggest is that you read it, you read Section 68, and then you know, you draw your own conclusions. And, you know, it's the only case we have which has really dealt with that in any degree. He does quote a couple of previous cases to arrive at his decision. But, you know, I think if we had another go at Section 68, if we were to argue it de novo, a different judge might come to a different conclusion. So I would be very interested in your thoughts. So I want you to apply your mind to that section and take it from there. Okay, we are done for today. 3 weeks time, infringement. Infringement's quite a biggie. And then we go into restoration and licensing assignments, etc., etc. So infringement doesn't look like a lot. It's only about 5 pages in Dean and Dyer, but there's so much case law on infringement, and you really have to go down into it. And there's all things about Bay-Dole, exhaustion of rights, you know, the role of expert evidence, contribute to infringement, all of these kind of things. So presumptions in relation to a new substance, marketing approval. So it's a lecture in and of itself. It's only 5 pages in Dean and Dyer, but we really go a lot deeper on the day. Okay, we're done. Thanks, guys. It wasn't a very long lecture, but it took us a while to get you. But you know where we are now and how we do things. There we go. Awesome. Thanks.
Thank you.
Is there a case book for patent law?
No, there isn't. There isn't. So for cases, so obviously you can't get away from cases in any legal. And for me, cases are, yeah, they're interesting. They're a part of the journey, but I don't like focus laser-like on patents. For me, cases are important because if it's an interpretation, like this one interprets 68. So if we're talking about 68, I want to see you reference this case, right? If we're talking about who's an inventor, then I want to see that. I want you to see that to reference that case because there's been a pronouncement on interpretation. But I will never ask a question along the lines of, you know, discuss Deaton versus McKelvey and versus this one. I know Prof. Alberts is quite heavy on case law. Yeah. Whereas because I work in practice, I'm more interested in how things break down or why we do things. Case law for me is just there to interpret the framework. I'm more interested in the framework and how it breaks down in practical applications. So, you know, my questions are always going to be along the lines of, you know, how this behavior, when you've got a corresponding patent, the law says the conduct of the patentee, how does that fit together? Why do they have these, that kind of thing, you know? So yes, I want to see case law, but it's not going to be like a huge focus. So I was thorough and I gave you every case there, but some of them are bold. And it's the bold ones that you need to have read. The other ones you can just read the head notes, or you can see how they're contextualized in terms of Dean and Dyer. But I don't expect you to have read every case, but I do expect you to have read the bold ones.
So does it mean that you have to find specific legislation regarding those countries?
No, don't worry about that. No, this was just today as an example of how what a court might take into consideration when examining the conduct of the patentee. That would just be an example of how it is. The important thing is the conduct of the patentee is considered by the court. And that's one of the things that's taken into consideration if they've got corresponding applications. So it's not the only thing that would be considered by the court when looking at their conduct. Okay, right, I'm going to stop recording and then we are good.